Welcome back. Thanks for staying with us. The Senzo Meyiwa murder trial has helped cast a spotlight on the use of the English language during court proceedings. Now, observers have raised some concern about what they call a one-size-fits-all approach to the use of language in a multilingual country such as South Africa. They have concluded that it may not even be practical and that it's definitely not transformative. Joining us to explain this further is Dr Zakeera Docrat, a post-doctoral research fellow in forensic linguistics, language and law at the University of the Western Cape. A very good evening to you. Thank you so much for your time. The use of language and its challenges came under the spotlight at the Senzo Meyiwa murder trial, especially as we saw during cross-examination, also observing Advocate Malisela Defo. Is a one-size-fits-all language policy approach practical in a multilingual country such as South Africa?
Good evening, Impo, and good evening to the viewers. Thank you for having me on the show. It's definitely not practical in South Africa, given that we have 11 official languages, English being one of them. But English obviously only being spoken by 9.6% of the population as a mother tongue. And also the fact that many South Africans don't have access to good English, and especially within a setting like courtroom discourse, where it's a heightened situation, and in a murder trial such as this, where your life actually depends on it.
So this restrictive language policy that favors English as a main language in court, what do you imagine then to be the impact when it comes to proceedings and the perceptions that may be created as South Africans watch?
Well, I think, this Meyiwa trial has really shone the spotlight, as you said in the beginning, from a point of perspective of the language of record being English only, from a point of the interpretation happening, police, as well as legal practitioners and their linguistic capabilities as well. And the English language of record policy that we currently have, which is English only, restricts us in terms of that it places sole reliance on interpretation in our courts. And we know in the South African context that is very problematic.
It in fact seems a contradiction of what is enshrined in the South African Constitution when it comes to language and the components of language and use.
Definitely, Impo. I don't think our constitutional drafters intended that our constitutional provisions just look pretty on paper and not be implemented practically. It also doesn't give effect to Section 6 of the Constitution, which says that our language should be treated equitably. And again, it boils down to, what is equitable use? Does it equate to equal use, and so forth? And I think that's where there are some loopholes. But it's also about taking a more inclusive approach. And I think if we go back to the constitutional provisions and we try and look at these loopholes and constantly harp on them like costs, and it doesn't say you need to use all the languages at all times in court, I think then we'll never start anywhere. It's about what we want to do and trying to find an inclusive approach to using the indigenous languages in courts alongside English. I also think people need to understand that we are not saying we need to get rid of English. That would be absolutely silly. We are saying we need to put our African languages in particular equally alongside English in court.
But Dr. Docrat, there's also a lot of judgment placed on English. If you look at vocabulary, if you look at accent, if you look at tone, and that in itself may result in a language prejudice, especially in court in the Senzo Meyiwa murder trial, where we listen to the cross-examination and Advocate Defo.
Yes, definitely, Impo. And I think, Advocate Defo running out of English words. I mean, his intelligence was almost judged on how well he could articulate himself in English, which is not a measure of his intelligence at all. And, you say about linguistic prejudice and subjective prejudice in this instance. I mean, viewers are judging me as I'm speaking here tonight on my accent and my tone, and that's natural. But not where we have judges as well judicial officers being insensitive to the fact that legal practitioners don't have a good accord of English and then giggling or laughing. It also speaks to linguistic sensitivity and how we react to this.
So what does it say now for police officers and the role that they should play when it comes to language and articulation?
Well, I think, again, the Meyiwa case shone the spotlight on the use of language for police officers when we saw Sergeant Mosia needing a Sesotho interpreter. And that he's well within his rights, as the judge pointed out to him, to say, look, you need an interpreter to assist you, and that's why we have interpreters. But again, it's not the fault of Sergeant Mosia, as it's not the fault of Advocate Tefo to have run out of English words, to not have high competency in the English language. It's about the system that we have in place, the policies and the legislation that enforce English, without allowing our police officers to undergo linguistic training. Just like our legal practitioners, the Legal Practice Act, the Legal Practice Council, all need to take a role and say, look, we need to be more active. How do we change our legislation? How do we change our policies? We need to work with the forensic linguists in the country and say, can we adopt a more practical approach that we can use across provinces where majority spoken languages are African languages? That's what needs to happen.
Yeah, and what about the sensitivity to the language complexities that do exist? I mean, that in itself should also be something that's approached.
Definitely, and that's part and part of linguistic training for judicial officers, for legal practitioners, for interpreters, even for the police. And that's something that we don't currently have in our system. We overlook language. We don't see it as an important component of our legal system. Yet everything happens through language, and language is law. So, like I said, it goes down to policy and legislation. But I'm not saying that we should get rid of everybody that's monolingual. We need to work on the system. We need to say, let's take the current cohort of monolingual practitioners, judicial officers, and train them to be linguistically sensitive. And as forensic linguists, this is our responsibility, to partner with the judiciary, to partner with government, to partner with the police. I think we're moving beyond the point of criticizing these state organs and saying, let us help you. This is a plea actually from me tonight saying, let me help you. And I know colleagues, Professors Russell Kishula and Manwabisi Khalakhala, Dr. Annalise the Press and our network, we are happy to help. And this is our plea tonight. Please let us help you. Let us find an inclusive approach to using our indigenous languages in our courts.
So where do you think the challenges will lie as you say that, help is available, there are ways around it, the policy and framework needs to be relooked at?
I think the starting point for me would be the language of record policy. In 2017, when that policy decision was taken to say English would be the sole official language of record, I think that was untransformative and it was totally misplaced. We need Chief Justice Zondo, hopefully, to take a more inclusive approach, and hopefully with President Mandisa Maya coming to the Constitutional Court, perhaps as a Deputy Chief Justice, she's more open to the use of indigenous languages as well. So we hope we can formulate some sort of dialogue, have a sort of meaningful engagement with our judicial officers and the judiciary more broadly, to say, let's work on a practical approach. Let's start piloting projects in specific courts. And we know there were courts in the Eastern Cape where pilot projects were run to use African languages, and those were never documented. So we need to go back to the very start and say, what happened with those pilot projects where we were using African languages as languages of proceedings and record? Can we use those models? What went wrong? How do we fix the system? That would be the starting point. And then obviously while that's happening, we need to start training our police officers from a linguistic perspective, where the criminal trial begins. We need to start training our judicial officers and our interpreters and our legal practitioners.
It's a complex matter, because South Africa is multilingual, but there are so many dialects within the 11 official languages.
Definitely, that's another issue we have. And, people are really quick to criticize our interpreters. And I know many of them are unskilled, but we have fantastic interpreters in our system. And interpreters often tell us that it's not just about interpreting between two languages, merely interpreting and translating words. It's about finding equivalence between two languages, two cultures, where there's often a linguistic and a cultural void, where some terms cannot even be translated into English. So, then there comes the issue of the dialects. And we know here in the Eastern Cape, where I'm currently based, we have many dialects. But that can all be addressed, as I say, through pilot projects where we will partner with the judiciary and we will come up with a practical plan that can be implemented in courts.
Some practical plans. Thank you so much for your time.